Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault. And you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy, do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy there.
Got the wrong guy, and the dog was biting him.
He roughing him up quite a bit. There's a lawsuit.
No, I'm not Peyton Ansley John Milton. I'm the agent authorized to represent Peyton Ansley John Milton as written in all capital letters.
Thank you. And as to Mr. Milton, is there a competency concern, or is this
I am not represented by anybody besides myself. In my sovereign capacity, appreciate you.
Thank you, Your Honor. I did have an opportunity to speak to him. I read him the reports.
Who is him?
Don't interrupt.
I read him.
You just be quiet.
Thank you.
I read him the report so that he will understand the charges against him. He didn't wish to hear anything more about his rights, and he does not wish to be represented.
All right, as we get ready to start up back with Kouri Richins, give me just 1 second. I will say that I think Fire Girl Handbite by Wendy was first in chat. Let me turn the music down just a tiny bit as we return to court. There we go. Sorry, trying to get right at the beginning here. All right, here we go. We're going back to court in the Kouri Richins trial, which is starting in just a second. Give us a tiny bit of audio. That was not it. I went to the wrong place. Do we have audio?
Drug cases.
Okay, we've got just a couple seconds. We'll get some audio in.
Because he's the guy.
This is not Burger King. People do not get to have it their way.
Here we go.
Right. Area where we see this happening.
Okay,
but it wasn't an expert witness exactly. It was a detective who was testifying based upon experience. And based on his experience, he said that in all his years as being whatever kind of agent he was in drug cases, he always saw this same profile of drug couriers.
I think he said most, didn't he? Isn't that the distinction?
It might have been, I don't know if it was all or most. It was most all.
The key part of the case is that he said most, and that's how Justice Thomas said, well, that's not
a key part.
Impermissible under 704B, because it acknowledges that there are some outside of most who don't know.
Either way, it's different because he was an experienced witness, not an expert witness. And in this case, Ms. Ayden is not an experienced witness. She didn't write this. She hasn't done, she can't get up there and say what the detective said in that case, because for a number of reasons. Other people did the studies.
May I cut to the chase a little bit here to see if we see it the same way? I agree with the defense that under cases like United States versus Wells, the expert testimony that Ms. Ayden offers cannot be used in the state's case in chief. And cannot be used in any part of the case as substantive evidence of defendant's guilt. Here, though,
they're asking for rebuttal.
The issue, based on the briefing, is more nuanced.
Thank you for the super sticker.
It seems to me that the state could use Ms. Ayden's expert testimony in its rebuttal case, and only to rebut a general categorical assertion by the defendant in her defense case that this is simply not how it works. This is not credible that someone would engage in a weeks-long campaign to kill someone in the absence of an imminent threat to their life or some kind of emotional or extreme impetus. If there's that kind of categorical, generalized argument made by the defense, then I think this testimony from Ms. Ayden, which is based upon a retrospective study of killings that actually occurred, saying in the retrospective study of killings that actually occurred, people did plan them over a varying level of time, and there were steps they took along the way. As long as the prosecution did not turn the corner in closing argument to say, well, we've showed you elements of plan and preparation on behalf of Ms. Richins. You heard Ms. Ayden, so that shows it's more likely than not that Ms. Richins killed her husband. They can't do that in closing. That would be using an inappropriate profile-like argument. But to rebut a categorical, generalized statement from the defense that this is simply not the way homicide works, I think that would be helpful to the trier of fact under 702A. Tell me why not.
Ooh.
Well, first of all, this would be the first time that it's ever used that way. You heard Ms. Ayden, this has never been used.
Well, that may be because it'd be the first time that a defense has ever made that kind of argument, but I'm not sure we're going to have to cross that bridge here.
Well, we may not. But I think it's never been used because it's not reliable.
Bailbird, thank you.
The study wasn't made even though to pick out individuals who commit violence. It was developed, she said, the only time...
They're not using it predictive in my hypothetical. They're only using it to rebut a generalized statement of murders don't get planned like this.
Well, it can't be used predictive. I think that was pretty clear.
Right,
It's
I'm agreeing
not.
with you on that. We're past that.
All right, so my point is that when she talked about individuals, though, she talked about how the study applied to assassinations. The study was not developed in any way, shape, or form to look at this sort of instance.
Let's be careful here. I think there's a side of the V that would call this an assassination of a non-political figure. But nonetheless, stay focused with me. Why wouldn't that be helpful to the trier of fact under 702A to understand sometimes killings are targeted? We know because we've studied killings that have actually occurred. Sometimes they're planned. Sometimes they take time for that plan to develop.
I guess I don't understand how that's helpful. Yes, isn't that general knowledge that sometimes killings are planned? I don't understand.
I don't know if it is or not, but it's that would be like if the defense is going to make the argument, these things are never planned. This is simply not the way it works. Now, I don't know if you're going to make that argument, but you're asking me to exclude Ms. Ayden under any circumstance, and I'm not sure you've carried that water.
Well, we're asking that she be excluded because it's under I'm going to move also under 403 and 404B. It's highly prejudicial for someone to get up there and tell a jury, I'm an expert, and it's if we were to make that argument, which I don't know. Let's see, we were to make the argument. She's a mother. She wouldn't have killed the father of her children. How prejudicial is it for someone to get up who claims they're an expert, who's not an expert, never has testified, never has used the study in this way, and then tell a jury why we're wrong?
Yeah, you changed my hypothetical. Ms. Ayden doesn't comment in any way on the specifics of one mother killing her husband or the father of her children. I'm not suggesting you can't make the argument that Kouri Richins had so much to lose by doing this, it reduces the likelihood that she did it.
But that opens the door for Ms. Ayden to come in under your hypothetical to say, no, that could happen.
Please stay focused.
Okay.
A general, absolute, categorical statement by defendant. Murder doesn't happen this way. They're always emotional. They're always in response to a threat. They're always as part of a fight or as part of a criminal enterprise. I don't know what you'd say, but
I think
if
the
you want me
judge
to
is not going to exclude her,
entirely,
but
I'd
it
have
also
to say
won't
that
come in.
there is no set of circumstances in this case under which her testimony would be helpful to the trier of fact, and you haven't carried that burden.
So you're saying that, in your view, the only way her testimony could be relevant is if the defense says
murder doesn't happen in this manner.
This kind of murder would only happen in a enraged, emotional state.
Yeah, or in response to a threat.
Or in response to a threat. That's the only way this is coming in.
Right.
Natalie OG,
that
thank you.
Seems to be correct. Tell me why that isn't correct.
Well, I don't know that we really even have a problem if that's the court's ruling, that it's only coming in under one specific circumstance. I just think our general objection, though, is that it's just not reliable under 702 under any circumstance. It doesn't matter what the circumstance is. I think that...
This is why I'm not persuaded by that. The defense keeps, at least implicitly, taking the position that if two people could apply this framework and reach different conclusions, it's not scientific, it's not reliable. Is that one of the defense arguments?
Well, one of many.
Sure.
It's not.
Now, that would mean that every physician that testifies in a medical malpractice case is unreliable, because in every single medical malpractice case there are competing expert testimonies regarding the standard of care and whether it was breached. And they're both admissible, and it all goes to weight, not admissibility.
I thought about that as I was listening to her testimony, and I think the difference is, and I don't do medical malpractice, but I think the difference is when we have competing medical experts, it's typically based on actual scientific research and knowledge, and
or
they might have different
training and experience. They're not citing studies most of the time,
but it's based in science. You can get two experts who have a different opinion when they apply the science, but this isn't any applied science of any kind. This is just a completely subjective theory.
But the law enforcement expert in Diaz wasn't applying science either, but he was offering specialized education, training, and experience. That's the subject of Rule 702.
Well, he was not an expert, that's true, but he was
in
applying...
Utah, he would have to be qualified as one in order to say what he said.
I know we see that in federal court all the time. They're applying their own experience. I am a DEA agent. I have arrested 1,000 drug couriers. Of those 1,000, the vast majority fit these characteristics. That's very different than what Ms. Ayden wants to testify to. It's very different.
I think the rigor of Ms. Ayden's testimony is greater in terms of, here are the studies. We looked at killings that actually occurred, identified these factors. We've published it. We've added it to the model. This is how we use it, full stop.
But none of those studies, well, first of all, she really didn't tell us what any of those studies were, but...
This goes to weight, and Dr. Fox will be able to tell the jury why this isn't going to help you make these decisions.
That's correct. But if none of the studies have to do with the domestic violence case, how is that helpful to the trier of fact?
Because if you're going to make a categorical people don't murder people this way statement, it has nothing to do with domestic violence anyways.
And I think one of the other problems is when she stated you can go all the way down the pathway of violence and then they don't commit a murder. So how is that even helpful?
That increases the reliability of her testimony instead of decreasing it, because it acknowledges that there are people on the pathway that fall off. So it's a most, not all, a la Diaz.
Okay.
So you're going to want the last word, because I think the state's going to quibble with my ruling here. Ms. Shervanek.
Your Honor, I don't know that I have much to add. I think that the type of testimony that Ms. Ayden would offer fits squarely within 702. She has specialized knowledge that would assist the trier of fact in making a fact of consequence more or less likely, and that they, being the jury, could use the analytical framework of the pathway to violence, taking the facts that they've heard presented or theories that they've heard presented through witnesses, and applying them to a framework that Ms. Ayden lays out to understand how a person in a position commits a murder under certain circumstances. That testimony assists the jury in understanding how this case could play out, how it explains a theory or rebuts the theory put forth by the defendant about how this murder was committed and why it was committed. And the jury can use the framework that she presents or wholly discount it if they find it doesn't apply, and that would be up to the jury to decide. But given the type of testimony that Ms. Ayden proffered and that we expect her to present as a rebuttal witness, it fits solely within 702, and for those reasons it's admissible.
Okay, I understand the state's position.
I agree. Judge can allow it, but I don't think it's coming in.
I guess my last word is just that under 702, I don't see any scenario under which this is a reliable science that could be presented to the jury. And I also don't think the testimony was that the pathway to violence is a most. It's an occasional. It's a few. So I don't think that they're to admit this is reliable under Rule 702 in any matter, I think is inappropriate.
Okay.
In retrospect, it might be reliable.
All right, the issue before the court is whether Ms. Amon's proffered expert testimony should be excluded in its entirety. The motion is made under Rules 702 and 403 of the Utah Rules of Evidence. The court addresses Rule 702B first. It provides that scientific, technical, or other specialized knowledge may serve as the basis for expert testimony only if there is a threshold showing that the principles or methods that are underlying in the testimony are reliable, are based upon sufficient facts or data, and have been reliably applied to the facts. Here, first, it bears noting that Ms. Amon is being offered as a blind expert. She is speaking about general principles, not applying a framework or analysis to the specific facts of this case. Moreover, her testimony is based upon a retrospective study of killings that actually occurred, and based upon that retrospective study, her testimony identifies some commonalities that exist among completed killings, while also acknowledging that people that begin on the so-called pathway to violence often fall off at any of the stages, sometimes begin again and then fall off again. That just because they begin on the pathway does not predict or mean that they will complete a killing. Under Rule 702A, the court finds that based upon her education, training, and experience, as shown in her CV, Ms. Amon is qualified as an expert in this field. And the court finds that her testimony based upon that retrospective study is sufficiently reliable and based upon a sufficient set of facts or data, given her description of those retrospective studies and their updates over time, to satisfy the minimal threshold for reliability under Rule 702B for a blind expert. The real issue is whether her testimony would be helpful to the trier of fact under Rule 702A, and under what circumstances. To be clear, under cases like United States versus Wells, 879 F. 3rd 900, which is from the Ninth Circuit in 2018, Ms. Amon's testimony cannot be used by the state in its case in chief as substantive evidence of guilt. And even if she's called as a rebuttal expert, the state cannot refer to her expert testimony as a basis for the jury to draw comparisons that would weigh in favor of a substantive finding of guilt. However, in the event that the defense makes an assertion in its defense case that is categorical and general, for example, something to the effect of that it's simply not credible that a person would engage in a weeks-long campaign to kill another person in the absence of an imminent threat to their safety, then Ms. Amon's testimony regarding the retrospective study of completed killings, showing a feature such as a preparation and plan over time, would be helpful to the trier of fact under Rule 702A to rebut that generalized categorical assertion by the defense. If the defense makes an assertion to the effect of Kouri Richins did not commit these crimes, and one of the reasons you can be sure of that is because Kouri Richins had so much to lose in her personal life and her family life if she had, that is a case-specific level that Ms. Amon's testimony would not be helpful in rebutting. However, if the defense makes a absolute or generalized categorical statement regarding how homicide unfolds or whether it ever unfolds as alleged in this case, Ms. Ammon's testimony would be helpful to the trial or effect in rebuttal. And it would not be unfairly prejudicial in a way that substantially outweighs its probative value, because it would not be able to be used by the state as substantive evidence of guilt. Rather, it would only be used to rebut the defendant's categorical assertion regarding features related to homicide. The court acknowledges that pursuant to this ruling, the likelihood that the defendant is going to make such a categorical high-level argument is pretty low, which means that the likelihood that Ms. Ammon will ever be called to testify is also pretty low. But the fact remains that there is not a basis to grant defendant's motion in full, because there is
a situation where it could
a cognizable basis upon which her blind expert testimony would be helpful to the trial or fact under Rule 702A, and which its probative value would not be substantially outweighed by the danger of unfair prejudice under Rule 403. So, the defendant's motion to exclude Ms. Ammon's testimony is granted in part and denied in part. She cannot testify in the state's case in chief. The state cannot use her testimony, even if it comes in rebuttal, as substantive evidence of guilt, either directly or by inference. And her testimony would not be helpful to the trier of fact to rebut case-specific assertions of why Kouri Richins did or did not commit the act she's accused of. However, if the defendant makes a categorical assertion regarding how homicides unfold, the court will revisit this issue to determine whether Ms. Ammon's testimony should be allowed in rebuttal. Let me pause there for a moment. Ms. Shervinack, do you need any clarification of the court's ruling?
No, Your Honor.
It really hamstrings the prosecution.
No, Your Honor.
Okay.
It's not going to come in.
Ms. Lewis, where would you like to go next?
We're doing Throckmorton.
We're going to do Throckmorton.
I guess we're Mr. Throckmorton would be
Okay.
next. So Ms. Nestor will be. Do you want to move or are you okay there?
So that was one issue. Now on to issue number 2.
Ms. Nestor, I have looked at Mr. Throckmorton's report from June of 2023 and his amendment in March of 2025. I'm really familiar with him from other cases in terms of his background and his method. Tell me what you see as the problem in this case.
So, Your Honor, can I come to the...
Wherever you're
I
comfortable,
hate bending
please.
over to
Yeah.
reach that microphone. Hold on.
Miss Nestor, who's coming to the microphone now, is Tyler Robinson's attorney.
May it please the court, good morning.
Also a high-profile
Your
Utah
Honor,
case.
as far as Mr. Throckmorton's testimony, the objections that we have to his testimony, it's basically focused on the first prong of 702, which is whether or not his testimony can be of any assistance to the finder of fact. And the main concern is his conclusions or lack thereof are basically, I looked at this, I cannot say at all whether Kouri Richins signed Eric Richins' name or didn't. I can't say she did. I can't say she didn't.
Right.
Handwriting expert?
You skipped a step, though.
Right. Well, I'm getting.
I mean, he does say with a much higher level of probability that Eric Richins didn't sign it.
Right.
He just can't say that it was with the same level of probability or any, depending on the document, that it was Kouri Richins that made the simulated forgeries.
Right. And the concern that we have is his materials that he provided and that we expect would be laid forward before the jury take little pictures of letters and compare them. And, all of us are human and we all have eyeballs, or those of us blessed with the sight have eyeballs that work. And we are tempted to look at those things and compare them and contrast them. And it goes back into a jury room. And the bottom line is they're calling the expert to say, I cannot draw a conclusion that Kouri Richins signed these, signed his name, signed the initials. His finding that Eric, I believe the finding he had was a strong probability that Eric Richins did not initial the documents, not that he didn't sign the power of attorney, but that he didn't even, a strong probability he may not have initialed them, which is not even to the standard of, beyond a reasonable doubt. It's not anything close to that. And the concern that I have is you're taking an expert who is going to basically say, here's all this stuff. I'm going to send this back in the jury room. Y'all can sit there and look at these initials. You can try to figure it out yourself if you think that he did it. But I'm, as an expert, saying I can't say Kouri Richins did.
May we pause there for a minute?
Yeah.
So my understanding of Utah law is that lay jurors can, in fact, compare signatures in the absence of expert testimony. That is something they're allowed to do.
They can, but the problem is you're trying to layer on top of that this expert who is giving an opinion that's a non-opinion to support a finding that the state wants, right?
Okay. Well, maybe.
And it's not supported by the science. The second prong that we're attacking...
Pause with me for a minute.
Pause.
I apologize.
No, it's fine.
So the concept of the state showing documents and arguing to the jury, take a look at these. You can see with your own eyes that doesn't look like Eric Richins' signature. That is permissible argument, and that is a permissible way to admit that evidence, correct?
I think they could try that. I mean, they could do that.
Right. Okay.
Right.
Then we look at, all right, does Mr. Throckmorton's analysis assist the finder of fact in determining whether the state has carried its burden of showing beyond a reasonable doubt that defendant forged some documents, right? And a step along that way, from the state's perspective, is, well, first we need to show that Eric didn't sign them.
Right.
So focus on that part for me for a moment. Why isn't Mr. Throckmorton's testimony admissible on that part?
Well, one big reason is that the initialing, there is no statement at all that Mr. Richins, so there's two documents at play. There's a power of attorney, which according to Mr. Burmester from the county, they're not even going to get into that unless we introduce the power of attorney as an exhibit. They're not even planning on doing it in their case in chief, which I just found out this morning.
Okay.
But let's say hypothetically for some reason we need the power of attorney. They're not even saying he didn't sign it. Like, their expert is not saying that's not his signature. They're only questioning whether he initialed each and every little blank on the side, right? Of which the expert cannot say. He cannot say he didn't. He cannot say to any degree of certainty whether Kouri did. He said absolutely no conclusion as to whether Kouri did, but he also can't say for sure that Eric didn't.
Well, doesn't he say that there is a strong probability that Eric Richins did not author the ER initials on the power of attorney that defendant allegedly used to obtain a HELOC?
Yes.
Okay. He's used a strong probability for that opinion, right?
Right, but that also provides for the possibility that Eric did initial it, right? I mean,
certainly,
yeah.
And the jury can weigh his testimony.
Right.
In terms of admissibility, it would seem to be helpful to the trier of fact to receive an opinion from a qualified expert as to whether Eric Richins initialed a document or not, right? Because if he didn't, it leaves open the possibility that somebody else did.
She doesn't want to admit that.
And then when we go to, well, does he have an opinion as to whether Kouri Richins was the one that initialed it? Right. I acknowledge that his level of certainty there is much lower, if not, there's no conclusion one way or the other.
Right.
But Why wouldn't you want to let that in?
Right. Well,
if the state wants to call him to say it, it certainly doesn't hurt defendant.
Yeah, if he testifies at all, trust me, we do want that to come in.
Yeah.
The concern that I just have is just misleading this jury about these floating standards, because under the National Institutes of Science report, under the PCAST reports, the reliability of subjective handwriting analysis has been brought into serious question by the general scientific community. I provided those materials in my brief. And to have a layer of persuasion going to the jury of an expert that is relying on a science that has not been generally accepted by the national scientific community. And I specifically identified where in the NIST report and where in the PCAST report the scientific community says, look, this is just a subjective. It's no better than if me and you and the deputy all sat down and just guessed if it looked like it matched.
Doesn't Mr. Throckmorton reference studies saying that certified handwriting analysts are better than the lay public at identifying differences in simulated forgeries?
He does, and we would obviously attack that if he took a stand vigorously. But yes, he does. He states that in his report, which may be enough to get you past the gatekeeping requirement. That's up to the court. I do also have some real concerns about whether portions of this needs to be redacted. One of the conclusions he was asked to, or he wasn't even asked, he did it sua sponte, I think only applies if it's a court, but he did it on his own when he was submitted the documents in question. One of the documents he was submitted on the amended report as recently as a few months ago. Now we're, 3 years after the death, and he's just now being submitted new evidence, right, to evaluate, but that's what happened. And they gave him a report by the, like a notary page where the notary had signed. And he just on his own makes a conclusion that a date has been altered. A number, not a letter, not handwriting. There's no evidence whatsoever that either that was asked of him to do, that he's qualified to do that there's any science backing that up.
I don't know that the state's offering that opinion at trial. Am I right about that, Mr. Burmester?
I don't even know what she's talking about.
Okay, so it sounds like a no.
Okay, well then if that report comes in, we're going to ask to redact that section of it.
Reports don't come in, they're hearsay.
Okay.
His demonstratives may come in.
Okay.
He usually he does in fact have demonstratives, and those will need to be disclosed to the defense, but the report's hearsay.
Right.
Lisa, I'm so sorry.
And also whether or not, that'll go to wait. We'll deal with that when he takes the stand. So I think really that it's really a two-based argument that we've presented to the court. Two bases for our argument. One is that we don't believe it's helpful because there is no conclusion. Number two, we question the science of handwriting analysis. I've provided the court with the scientific community's concern about the reliability of handwriting analysis, that it's really slowly but surely being relegated to junk science. And on that ground, we think, and what it adds is minuscule. It provides no guidance to the jury. So as far as we're concerned, if you're going to exercise a gatekeeping function at this point, this would be the point to do it. And we would ask that he be prohibited from testifying as an expert in this case.
Okay. You'll get the last word.
Yep.
Mr. Burmester.
To clarify, the state would offer Q1, Q2, Q4 in the event arguments come out in the defense case in chief. I don't know. We come up with 100 hypotheticals, but maybe something, she's a great businesswoman and somehow puts into question evidence that we might offer, which could include that power of attorney.
And Q1 and Q2 are definitely the power of attorney. Is Q4 also?
Q4 is when Mr. Throckmorton has asked, all right, we have some knowns from Ms. Richins.
Right.
Now, do the same thing you did.
Okay.
So, with regard to those would only, that is how I would see us calling Mr. Throckmorton in rebuttal. Main point is there's not an agreement that they have to introduce the power of attorney before we would introduce it. It would be a whole set of facts that might make that come about.
Is the power of attorney, forgive me, I didn't go back and look, is the power of attorney the basis of one of the forgery charges?
It is not.
Okay. So why would the power of attorney be discussed in your case in chief at all?
Oh, I'm not offering the case in chief.
Okay,
That's
got it.
precisely why.
I see.
It would have to be some facts that arise in the defense case.
Got it.
That would implicate offering that exhibit, and therefore its authenticity would be at issue.
Understood.
Okay. So that leaves us with just the true stage application signature, which is indeed at issue, identity of the forger and identity of that insurance fraud count.
So there I understand the state's argument to be Mr. Throckmorton helps the trier of fact determine whether we've carried our burden on the forgery count related to that insurance application, because he says, he opines that it was probably not authored by Eric Richins, and it appears to be a simulated forgery, full
Correct.
stop.
Yes.
Okay. And that, in the state's view, is circumstantial evidence that makes it more likely that it was forged by Ms. Richins.
Yes.
Given other factors related to motive, access, etc.
Yes.
Okay.
I get the sense. I was in the courtroom in Gersh v. Gersh, so I know the court is familiar with Mr. Throckmorton, and we've proffered all those in our pleadings, all his qualifications. So I don't intend to talk about that. However, there is a notion, and Mr. Throckmorton is here, President Court, we can call him as a witness. He would talk about how handwriting comparison has been used in courts for 200 years. And since the 70s, there's been an intense professionalization of that theory. And that history goes to prong C for demonstrating its threshold. I would also just like to address two other things, and that is the pathway forward, 2009, where the scientific committee, who's addressing all, what is the status of every single forensic science? And there's a portion about handwriting, and the committee agrees that there may be some value in handwriting analysis. The scientists who composed this document, of course, hold DNA at that time as being the gold standard. Obviously stated there were some things that need to be addressed, but certainly doesn't say it ought not be admitted. PCAST doesn't even directly address handwriting. It says all these other sciences like handwriting, these same things should be applied to them. But none of them say scientific community is rallying around some notion that it's junk science.
Certainly not in the state of Utah. I've looked. I cannot identify any time that Mr. Throckmorton has been excluded in the state of Utah. I can only find cases in which he's been admitted as an expert.
Unless the court has further questions.
I understand the state's position. Ms. Nestor.
Nothing else, Your Honor.
Okay.
He's coming in also just for rebuttal.
Before the court is the
judge loves giving
defendant's
his-
motion
he's like-
to exclude the expert testimony of Matt Throckmorton. Mr. Throckmorton is offered to testify that the Eric Richins signature on the True Stage insurance application that is the subject of the charged forgery was probably not authored by Eric Richins and appears to be a simulated forgery written by someone who is familiar with or has access to Eric Richins' known signature. In addition, Mr. Throckmorton has been noticed as someone who may offer testimony in rebuttal or impeachment that there is a strong probability that Eric Richins did not author the ER initials on a power of attorney that the defendant allegedly used to obtain a HELOC on the Richins home, and that there are mere indications that the defendant wrote those initials. The court determines under Rule 702A that testimony, which would come in the state's case in chief and perhaps in rebuttal, respectively, is helpful to the trier of fact because it would assist the trier of fact in determining whether the state had met its burden to show that Ms. Richins committed the charged forgery count regarding the True Stage insurance application and may be relevant to show Ms. Richins' conduct related to the HELOC in rebuttal. Moreover, based upon the court's review of Mr. Throckmorton's CV, his education, training, experience, and his substantial history and experience in testifying, certainly in state courts in the state of Utah, the court finds that he is qualified as an expert in the field of handwriting analysis. Regarding defendant's objection to the reliability of Mr. Throckmorton's analysis, the court finds that his analysis and his methodology, and therefore his testimony, are sufficiently reliable under both rules 702 subsections B and C. Under C, the court finds that Mr. Throckmorton's analysis, because it is performed consistent with and measured against the SWIG-DOC standards, is generally accepted by the relevant handwriting analysis community. Moreover, even putting that aside, the court determines that his methods are reliable in as much as he is able to describe the way he compares the questioned documents to known samples of both Mr. Richins, the decedent, and also Ms. Richins, the defendant. He applies that reliable methodology to a sufficient set of known signatures, and he does so in a way that does not ignore any uncontroverted features of those signatures or other uncontroverted facts. That is, he applies his methodology to a sufficient set of facts or data in a reliable manner. Therefore, his testimony is admissible under Rule 702B. Finally, the court is not persuaded that his testimony, the probative value of which has been described, is substantially outweighed by the danger of unfair prejudice or other concerns under Rule 403. For these reasons, the defendant's motion to exclude Mr. Throckmorton in his entirety as an expert witness is respectfully denied. Mr. Burmester, do you need any clarification in the court's room?
No, Your Honor.
Ms. Nestor?
No, Your Honor.
Okay. Next.
We're going to get done today.
Okay.
This next witness, Ms. Nestor, is also handling that one.
Very good. You ready to turn to Dr. Venino, Ms. Nestor? Ms. Shervanek, is this one yours?
Yes, Your Honor.
May I ask you a couple of questions?
Yes.
I'd like this judge on the Supreme Court. He's really good at asking questions from both sides.
Ms. Shervanek, is there any admissible evidence of domestic violence by defendant against Eric Richins prior to the allegations related to February 14 of 2022?
I don't believe that would be presented in the state's case in chief.
Okay. Is there any admissible evidence that Eric Richins had any subjective knowledge that defendant attempted to poison him on February 14, 2022?
That he had knowledge of it?
Right.
Yes.
Tell me what admissible evidence there is of that. We went through this for a couple of hours with Mr. Wright.
We did.
I spent some time on this yesterday. I don't know that there's any other admissible evidence that would show that Mr. Richins knew that anybody had attempted to hurt him.
May I have a moment?
Quick huddle.
Of course.
Quick huddle for the prosecution team. How do we answer this one? Mr. Bloodworth? Comes back in. Everyone's having little conversations here. I think it's interesting that Kouri has her handler next to her. Don't interrupt the attorneys. So Kouri's our public defenders. She doesn't have any money. She was upside down. The state's going to argue that's part of the motive. I think the key here in the judge question is what admissible evidence. What would be allowed to be admitted to court that would show that Eric had any indication that someone was trying to kill him?
I think the court is aware of what the admissible evidence is. The testimony from
He said he's not
Josh
aware.
Kays and Cody Wright that the
Cody
admissible
Wright's not going to testify, as I understand it, trial, pursuant to, not at least regarding the events of February 14, 2022.
Pursuant to what?
I don't think he has any admissible testimony regarding that day.
He does. His admissible testimony are his observations, not the content of Eric Richins' conversation, but his observations about Eric Richins' demeanor.
You didn't see him. It was all on the phone.
Right, but his hearing observations about his voice, how he seemingly sounded on the phone during those conversations, and not the content that aren't admissible because of hearsay rules, but there are observations that he could make through that phone call that is admissible.
Lisa, welcome. Thank you so much.
Proffer that for me.
Proffer.
This is exactly what Mr. Wright testified to previously.
I don't know that he can give that testimony regarding his observation of the manner in which he was talking without saying what he was saying.
I disagree.
Okay.
You're proffering that Mr. Wright would say he sounded scared?
That he sounded somber, that he sounded concerned. I don't remember the exact words that he used when he testified, so I don't want to misstate those. But certainly he testified that during that phone call, Mr. Richins had a certain demeanor that struck him and that he remembered, and then he testified to what that demeanor was.
Okay. All right, let's assume that comes in. Anything else?
There are also text messages between the defendant and Eric Richins about the sandwich that was left, and
So let's be specific. There's a text message from June between defendant and her friend indicating that she left a sandwich. And then there's a text message from Eric to Kouri at 11:33 a.m. on February 14 saying he's not feeling well, I'm going to go lay down. If I don't feel well, I'll go to the hospital. Anything else?
later in the day. Sorry, I don't have all of those messages at the forefront of my mind.
That's okay.
Your Honor, late in the day, late afternoon on February the 14th, there are text messages between the defendant and Eric Richins, which don't directly, he doesn't directly say something like, you just tried to poison me or something.
No.
But the state will argue that his messages and her non-responses for several hours, and then their ultimate exchange about, he says something like, I got dinner for you and left it on the seat of your car, or on the seat of my car. The state will argue that those indicate he was well aware of what happened on February the 14th at about 11 a.m.
Okay. All right. Okay. My concern is that in the absence of admissible evidence, in the absence of the jury hearing the content of Mr. Richins' statements to Cody Wright, there isn't a basis for the jury to conclude that Mr. Richins was acting inconsistently by staying with Ms. Richins or not doing something more acute between February 14 and the day he ultimately died. And without a reasonable basis to find that he acted inconsistently, I'm not sure why Dr. Venino's testimony is helpful to the trier of fact. And I'm more concerned that under 403, it would invite the jury to speculate about whether there was, in fact, a prior history or prior experiences of domestic violence that aren't in the record.
I think there are other instances, other facts that would be presented at our case in chief that are maybe not on their face what people typically consider domestic violence, meaning physical abuse. And that's the crux of it. For example, if there is infidelity, why do you stay in a relationship? For example,
But
if
does
someone
Dr. Venino have anything to say about that?
What's that?
Does Dr. Venino have anything to say about that?
I think these go to the counterintuitive behaviors. These go to manipulation and control that exist outside of physical abuse in these types of relationships, which is exactly what needs to be explained. Because the jurors may have questions of, why wouldn't you leave if you knew you were being cheated on? Why wouldn't you leave if you thought this person was taking your money?
Well, hold on. The lay jurors are perfectly capable of figuring the first one out in their everyday experience. The second one as well. The state, I think, has a more thought-provoking point of, if you knew somebody tried to kill you, why'd you stay with them? Now that, I understand, would require or may allow the admission of specialized knowledge regarding domestic violence relationships and cases. I got that. That's, I think, a valid argument. I'm just not sure there's any foundation for the jury to conclude that this relationship involved domestic violence before Mr. Richins ultimately died.
I think that the court is considering this as domestic violence in the context of a typical physical abuse case that we're not alleging.
I'm not suggesting otherwise. I'm more concerned with Dr. Venino talking about it that way.
And she would not.
Then what does she do that's helpful?
It's in her proffer. She can certainly testify to it, but it is the counterintuitive behaviors, it's power and control and manipulation outside of physical abuse that does not include physical abuse.
Okay. All right. Mr. Bloodworth, did you want to add anything?
Yes, Your Honor, thank you. As it relates to what I would most likely expect the testimony to involve, Valentine's Day. Why not? Why if you thought she just murdered you, do you still stay?
Right.
And it seems to me that where the court might be hung up is in the probative value of the evidence showing that he knew versus
or lack of evidence showing that he knew.
The probative evidence showing that he knew versus the prejudice that would come along with perhaps an improper inference.
An improper inference of something prior to February 14th.
Prior to February the 14th,
right.
Correct, Your Honor. So I don't know that at this point in time the court has the full amount of evidence that Eric knew, despite kind of some proffers just now. This may be a decision that the court wants to reserve on under the scope, kind of make the reservation of the court needs to hear the evidence that Eric knew. Upon hearing the evidence that Eric knew, the court can make a 403 decision. I think the court can make probably the 702 decision part of that today, but I think the court needs more information on the probative value of the evidence that Eric knew.
Okay. Pause there for a minute.
Yes, sir.
Ms. Nesser.
Your Honor, Ms. Dr. Venino, I think she's a doctor, she has certainly not been identified as a family relations expert, a good or bad marriage expert, a marriage counselor.
I know, but respond to what Mr. Blightworth just said.
That's what I'm trying to get to. So if they're trying to argue that there's been infidelity or there's been arguments in their marriage, infidelity on both sides of their marriage, which is an answer to a question about why you wouldn't leave. But that goes way beyond what the narrow area that she's qualified in. She's qualified in domestic violence. If you look at her CV, 99% of it deals with sexual assault victims. A tiny percentage of it deals with domestic violence in the home that is not connected to sexual assault. Almost all of it's connected to sexual assault. So her specialty, while they may want to put that case on that, that she was a bad wife or whatever they want to try to argue, this expert is being called to opine about violence in the home, not just being a bad wife or being controlling or manipulative of your spouse, but of a spouse being in fear due to emotional or physical coercion to the point of being in fear. And there's zero evidence that I've seen in 10 terabytes. What are we up to? 12 terabytes? Whoa. 12 terabytes of discovery. And if they've got some evidence out there that there was domestic violence in this relationship and I don't have it yet, I submit it's not coming in. So the prejudice would be outrageous to allow this witness to get on the stand and opine expertly that because there were problems in the marriage, that this was a situation that put Eric Richins in fear of domestic violence.
That's not what Mr. Bloodworth was arguing. He was arguing that I should wait to see how the evidence comes in the state's case in chief to determine whether they've laid a foundation for the jury to draw a reasonable inference that Eric Richins did in fact conclude subjectively that Kouri Richins tried to kill him on February 14th and then stayed with her. If they do, I think their argument that Dr. Venino's testimony is helpful to the trier of fact is stronger, and we can have a conversation about it today or tomorrow or in the future. If they don't lay the foundation, I don't think it can come in because it won't be helpful to the trier of fact. And even if it had some minimal helpfulness, it's the danger of inviting the jury to speculate about whether there was some other history prior to February 14 regarding domestic violence, whether they've misheard the evidence and are confused or misled. That's too high under 403. But Mr. Bloodworth's point on behalf of the state is, rather than doing this by proffer, why don't you just hear it come in and then decide if we can call Dr. Venino after we've tried to lay the foundation for what we think we're going to be able to show.
Well, one of the problems is, if she's going to come in, there's things we as lawyers need to do to prepare for that. One thing, we may want to get a rebuttal witness. We honestly did not believe that her testimony would ever come in at this trial because there's zero evidence of domestic violence on Kouri's part, right? So there are things we need to do to prepare that preparing at the last minute puts us at a significant disadvantage. I think you're always entitled to revisit any ruling you ever make, right? You're the judge. You can revisit a ruling at any point in a trial if the evidence changes or something changes.
Certainly.
But as this evidence stands right now, they have not propounded evidence sufficient to get her testimony in at this point. If they do that later, then they can ask you to reconsider. But right now, I think the only proper ruling would be to rule that there's no standing right now to let her testify. If that changes, you can reconsider it. But right now, they've not propounded that evidence. I've never seen that evidence, and we're, a month out from trial. I seriously doubt we're ever going to see it. But that's what we would ask you to do at this point.
You acknowledge there's a little bit of internal inconsistency to what you just said. I agree with the last part that I can say, well, she can't testify until you lay foundation.
Right.
But once I say they've laid foundation, you're going to be right on the horns of the same dilemma you just described in terms of needing to have a rebuttal expert prepared to go.
Right.
Okay.
Well, I mean, if it depends on your ruling, how we approach that, right? I mean,
talk to me about, assume that there was foundation in the record today, that there was admissible evidence that Eric Richins had a subjective belief, well-founded or otherwise, that Ms. Richins attempted to poison him on February 14, 2022, and elected not to do anything about it.
For Valentine's Day, how sweet.
It would seem that that would satisfy the 702A standard for helpfulness for the jury in terms of explaining why people who suffer violence in a domestic relationship don't immediately get out of it.
That still doesn't mean that there's any evidence of that violence in the relationship. Even if
you got to accept my hypothetical.
Right.
That he subjectively believed that she did and didn't get out. That would seem to open the door to Dr. Venino's testimony as helpful to the trier of fact. Do you disagree?
I would disagree with that.
Tell me
obviously. Why. Well, based on her area of expertise, as I read her proffer, her theory is, it's almost like we use the word grooming in child sexual assault material cases, but that idea of being in such a violent and traumatic relationship that basically a person just gives up. It's kind of the
Well, that's not what she says. I mean, quote, there are many reasons that a victim of intimate partner abuse doesn't simply leave an abusive relationship, including love/hope for change, economic constraints, lack of perceived acceptable alternatives, social isolation, and fear.
Right. There's no evidence of any of that.
But in my hypothetical, there would be evidence that he believed that was the case.
Okay. Accepting that hypothetical, that evidence that does not exist now somehow appears at trial for the first time ever,
right,
and is allowed in, even though we object like crazy because they didn't give it to us before. The argument would be that her testimony, my understanding is she's a blind expert, right?
Right.
So she's not going to be able to take that evidence and analyze it anyway. So how does it change her position at all from right now?
Well, because right now, in the absence of the foundation that you assert is missing, that I have concerns is missing, that Mr. Bloodworth is saying, hold the phone, let us lay it at trial. I agree that her testimony would be unhelpful because it's not relevant to the facts of the case.
Right.
If they lay the foundation, it suddenly becomes relevant to the facts of the case.
I don't know. I think it gets very, very painfully close to opining on the mental state. I mean, it's the same argument that you raised before when you were talking about the testimony of the profiler, right? Like, how close are you going to walk to that line that you're giving an expert opinion about what's inside someone's brain and then extrapolating that one step over to defense counsel table, right? And I mean, basically her testimony would be under circumstances where someone believes that their life is in danger. It's perfectly rational for them to stay, so it must show that they did believe it, but that they just didn't act on it. I mean, she's opining on what would be in Eric Richins'...
they'd offer her testimony for the inverse.
Right.
The fact that he didn't leave is not necessarily an indication that an attempt in his life didn't happen on February 14th.
I mean, I had a case very similar to this one time. I had a rape case where the victim of the alleged rape testified wholly inconsistently, like 6 different times about what happened to her, to the extent of like where it happened, how often it happened, in what position it happened. Everything was just absolutely in every statement she gave. And the federal government called a witness to testify, an expert, to testify that rape victims are more likely to be confused. So the fact that her statements are consistent with trauma and make it more likely that she was a rape victim, right? And we have this huge battle over that, about how far can you use an expert to explain away your inconsistent evidence, right? Evidence that's inconsistent with guilt. And it shouldn't be that you should be able to call an expert witness and say, hey, we're presenting something that's wholly illogical and irrational, but we're going to call this expert up here and say, well, this certainly would be a perfectly honest reason why Mr. Richins would believe that, it was a healthy thing to stay with someone who just tried to murder him, right? And so it eliminates their problem with their evidence, and it goes into his state of mind, which an expert shouldn't be called to testify about.
Well, we could talk about that under Diaz.
Right.
But, okay, I understand your position. Yeah. Ms. Shermanek, Mr. Bloodworth, anything else today?
No, sir.
Okay. Let me take it. Oh, I'm sorry.
Sorry, Your Honor.
That's okay.
Judge wants a break.
Anything else on the record at the moment?
No, sir.
Let me take a 10-minute break. Okay, thank you.
Judge says, we're going to go for just a minute, one more time, another 10-minute break, and then he'll decide this one as well. Okay, I love this judge. Very intimidating. When I was there in the courtroom, when I was there for the Kouri Richins hearings, way back. The idea came up that I might have to talk to the judge because I had a differing opinion as to the court's interpretation of a rule. And quite intimidating. I ended up not talking to the judge, but
call from
good.
Angela.
Angela, hello. How are you doing?
Hello. I'm doing great. You?
I'm doing well. Happy New Year.
Happy New Year's and happy holidays. And to fellows who celebrate Christmas today, like I do, Merry Christmas.
Oh, yeah. You're late.
Well, yeah, we are, kind of. I'm
right.
Sorry.
It's good any time of year.
Well, not really. Not really. Well, we have a pope in the 15th century to blame for this for 2 Christmases.
Hey, if we get another holiday, I'll take it. It's good.
Yeah. Yeah. Hello. It's a new year, and I hope that we have a great year like last year. We have lots of great cases. And Richins is soon. So I'm looking forward to that.
We're about a month away from this one. So this is one of the last hearings where they're fighting over who gets to testify. And it's funny. I would say in this one that the defense is sort of tilting at windmills. They've picked battles for experts that, a whole series of events would have to fall into place for this to happen. But Judge, in case it does, we'd like you to rule right now and say, no, don't allow it. And the judge is looking at it and saying, but there are a whole bunch of different series of events that could happen where it would be allowed. So it's sort of funny that way. But
but I do like prosecution that they're like, they don't want any surprise to happen, you know?
Yeah. There shouldn't
they're
be.
like,
That wouldn't be
there
fair.
shouldn't be. We're like, no. And we know who love to do surprises. Hint. Yeah. Well, sorry. So I like that prosecution is like, here's what we want to do. Here's what we want to argue. Here is what might happen. Not sure, not 100% sure it will happen, but may happen. And we would love to, do the due diligence and warn you, the court, and the defense, which is what I love. Seriously.
Yeah.
Can we have more cases like that, please? Can we have more hypothetical stuff?
I love that he brings these hypotheticals and he forces them to deal with it, right? He's like, no, you must accept the scenario I just built and now answer me to this. Because it's what he has to look at. It's like, you want me to rule based on what you think is going to happen, but I can look at this and see a different series of events that may happen. And how would you deal with that? So I love it. I think we need to find some more cases this judge handles. He's out of Park City. He's in Summit County, Utah. The courthouse is pretty nice. It's a nice courthouse. The mirror you're seeing in the back of the courtroom, that's actually the press room. But the press don't use that room unless they have to. If there's a jury trial, the press use that room. But when I was there, we actually used the jury room for the press. So I sat around the table where the jury will be deliberating Kouri Richins' fate if this goes all the way to trial. So interesting. Go on.
Well, you just reminded me that. No, I forgot. Never mind. But I forgot to say one big thing, and that is because I might have said it, but it was a long time ago. While I was in Switzerland, I found something great, and that is the course I'm taking this spring, something that I said I will never do, and that is going to law. Yeah. I'm specifically taking the sociology of law class this spring, and I'm starting on January 19th.
Awesome.
So it's going to be fun. I'm looking forward to it. I just got the email today with the curriculum and all the stuff that all the necessary stuff to prepare before 19th. But it's not a lot, but it is fun. Sounds
fun. Well, it's great. I'm glad you're having a Happy New Year and Merry Christmas now that you're finally there as well. So excited for that. Let me know how things go with the course.
And at the end, we are going to a little what I saw. We are going to actually look at the cases and analyze it, which is the core of the classes, like sociology of law, how to apply law to the criminology, to criminals and criminal cases, and I think even civil cases, because of the curriculum. We are also talking about civil rights, and
that opens up a world of things to talk about. So. That's cool.
Yeah.
That's awesome.
We're even talking about, it is. And I'm very much looking forward to it. So I'm going to be diving into law this spring.
Awesome. Angela, that's exciting.
Something I said, it is. That's a lesson. Never say I will never do something, because you never know the stuff. Because I said I will never go into law, and look,
a wise person once said, make your words soft and sweet, so when the time comes for you to eat them, they will taste good and be easy to chew. So,
yeah.
Angela, thank you very much for the call.
I am going to say something the Fire Girl handmade by Wendy said. Don't forget to hit that like. Don't forget to leave the DNA at that like button. Don't worry, CPD and MSP won't collect it in these red lookups.
Yes, click the like button. Angela, thank you very much. It's great talking to you. Have fun in your class.
Thank you. Bye.
Bye.
Thank you. Bye.
That's awesome. Yes, never say I'll never do this, because sooner or later you'll find yourself doing that. All right. I want to see this judge. I want to see more of this judge in criminal cases, obviously, not just because he has the most amazing voice and the audio system in the Utah court system actually works fairly well, so it captures it pretty well. But he is so much fun to watch when he's questioning in this situation where he's directly questioning the lawyers, right? He's different with a witness. He's more objective in his questioning, but when he's questioning lawyers back and forth and challenging their argument, he is so good about putting the questions, asking the question from the other side. And you're like, oh man, this judge hates this lawyer. He's in for him. And then he'll flip to the next person and he'll ask the question the other way. And his ability to change perspective like that and be, thorough and in depth in how he understands the issues. It's amazing. So I want to count the judge's questions. I hope he asks questions during the trial. Oftentimes we get a judge like this who is very verbose before trial, and I'm strictly a referee during the trial. And I'd hate to see him be muzzled or gagged in that way during the trial when he's got such an amazing voice and a brilliant legal mind as well. All right. Let's see. It's only about a 10-minute break. We'll be back here in just a minute, so give it a second. A couple more minutes, we'll be done. Let's see. You think there will be jury questions? I don't think so. I'm trying to remember. I don't remember us covering too much out of Utah before, other than the Gwyneth Paltrow ski crash case. That was a civil case, also out of Summit County, same county. I don't know. I really don't know. I hope there are jury questions. Somebody in Utah, if you've served on the jury, just let me know. Did you ever get to ask questions on the jury? And it could be specific to the judge as well. So I don't believe the judge is single. I think he is married. That's my understanding. Not that matters to anything, but I saw the question and thought I could answer it. I'm collecting signatures for initiative to force juror questions in all cases. I got a guy I can refer you to a guy who can help. Per Google, yes, Utah juries can be allowed to ask. Okay, so this is important. Can be allowed, right? Because I believe that almost in every state, the judge may be able to say, no, you can't. There are some judges, I think Judge Newman, actually, he didn't even allow the jurors to take notes during the Murdaugh trial. Do you remember that? I think if I remember the right case, I think during the Murdaugh trial, they couldn't even keep notes. He wanted them to just focus and not have anything to distract them from the testimony at hand. But yes, at their discretion, we allow jurors to submit written questions to witness during trials in accordance with Utah rules of civil and criminal procedure. So it's up to the judge. I hope the judge allows it. That would be awesome. Judge seems to value questions. He has some good ones himself. I hope he thinks the jury will bring up some good ones as well. But I will say that several times today he's looked at an issue that he has to decide, and he looks at it from the vantage point of, will this help the trier of fact reach a decision? And if that's the light he looks at everything with, I would think that allowing the trier of fact to get clarification or additional information about an issue would be something that he would deeply value. So that would lead to yes on the question. So I'm going to say he's going to say yes. All right. Let's see. Keep the audio here. You'd rather... I'd like judge questions as well. Kouri Richins trial, by the way. This is the Kouri Richins trial, which starts next month. And this trial is very, very unique in that, first of all, it's very high profile. I know there are a lot of high profile trials. Kouri Richins is accused of poisoning her husband with an overdose of fentanyl. And as we heard in some of the arguments today, there may have been 2 attempts at that poisoning, the first one obviously being unsuccessful. Kouri Richins did more than that, though. After her husband passed away, she wrote a book, a children's book for her kids about grief and losing your father. And I think the book was called something like Are You With Me? Or Are You Still With Me? Or something like that. And she went on a book tour and went to the morning TV shows and talked about her book. And it was so sad, that just in dealing with her grief and helping her kids deal with their grief, she came up with this book, and it was selling like crazy. And and now she's accused of being the one who did the murder, who did the bad thing. And it has twists and turns all over the place. Obviously, her last lawyer, who had to recuse herself because of a conflict, Sky, she was a firecracker. Man, when she actually left, like when she filed the motion to recuse herself, she filed that in the last of a series of motions, but all the other motions before just like burned the bridges, attacked everybody, tried to recuse the judge, the prosecutors, change event, everything. She threw everything at the wall, and then she's like, and by the way, I quit. I must be recused because of this conflict of interest. We have issues with documents that were found in Kouri Richins' jail cell. Specifically, there's the walk the dog letter. And you say, what's the walk the dog letter? Well, it says walk the dog on the top. That's why we call it that. That's some sort of code word. This was a letter that we believe was intended for her mom, who was visiting her in jail, and Kouri Richins would hold papers up to the glass for her mom to read, and then she would take the papers back and presumably shred them and flush them down the toilet. This is one that either had not been shown yet or had not been shredded yet, but it was kept in a folder that was for lawyers' eyes only, was marked, for attorneys' eyes only. But it was this letter clearly to her mom, giving a series of instructions as to what to do in the case. The way I read this was a list of how to tamper with witnesses, how to completely defeat the legal system by telling people to say things, telling people to produce this testimony, planting this evidence here. It was nuts. So lots of good stuff to be coming in this trial. It's going to be quite spicy. Ladybug's mom, thanks for the super chat. Says, I was forced to do some adulting today, so I've been in and out. I missed you guys. I'm sorry, Ladybug's mom. Sometimes real life calls. Her own words are going to convict her. It's gonna be great. It's gonna be great. Can't wait to hear her jail phone calls. Her mom is interesting. I hope we get to hear about her mom in this trial. Oh, speaking of interesting.
Call from Allie B from Tennessee.
Allie B, how are you doing? Hello.
Well, not so well, and don't get mad at me because I got to derail a little bit, but I have an emergency for you in the chat.
Uh-oh.
I had a little run-in, which I'm traumatized by. I'm over it, but I was bawling my eyes out with a skunk, okay? And in my car. And, y'all, I went through the wash thing 2 times, and I'm traumatized, and I can't get the smell away, and I don't know what to do. If anybody has any ideas.
Could I ask about the skunk? Is it okay?
No.
I'm sorry.
No.
I'm sorry.
R.I.P. skunk. I know. I've never hit an animal before I died.
Of all the animals to hit, the skunk is the worst one.
Right? Am I being cursed?
Here's what I suggest.
I don't know.
Here's what I suggest.
Okay.
Undercarriage wash. Hear me out.
Okay.
There's a car wash that washes mostly the top. The skunk is lower. Most of the smell is under the car. I would take it to one of those places where they wash your car for you and just tip well. Just
like just get it detailed?
That or wash it with tomato juice. If you've got a pressure washer where you can
Y'all.
Yeah.
I'm so traumatized. Even I told a friend about it last night, and then this morning she said, surely you didn't hit the little baby on Highway 100. And I was like, I did.
She's like, that was you?
Oh,
everyone smells it now.
Everyone's seen it. It's so sad. But anyway, I feel horrible. I feel like a criminal. I really do. But the smell is just outrageous. So sorry for interrupting, but it's just on my mind.
You could always
confess and ask for help.
You could always sell your car. That's something you might be able to do. Try to do it sight unseen.
It was a skunky car.
Like a Canva thing online where you can hey, I've got this car. I'll tell you the details. Making me an offer. And they make you an offer. You're like, sold. And then
I can add the tomato juice, and they'll think it's been in a crime.
Yeah.
That's what I felt like when I went through the wash last night. I was like, dang, this is like what our criminals do.
Yeah,
But anyway.
It should fade. It should fade over time, but an undercarriage wash. Hey, we've got to go back to court. Undercarriage wash.
Bye. Sorry about that.
All right. Thank you very much. We'll see you.
All right. The issue before the court is the defendant's motion to exclude Dr. Sherry Venino, who is an expert noticed by the state or disclosed by the state to give testimony about domestic violence relationships, to include characteristics, dynamics, patterns, and victim trauma. Dr. Venino is disclosed as a blind expert who is being offered to testify regarding a set of principles regarding domestic violence relationships without having reviewed or opining on any case-specific evidence. The state asserts that characteristics of domestic violence victims are relevant because when applied to the facts of this case, they will help a jury understand, for example, why Eric Richins continued to live with the defendant after she allegedly administered fentanyl to him on February 14, 2022. Currently, the court has not seen in the record a non-speculative basis for the jury to draw an inference that Eric Richins had any subjective knowledge of Ms. Richins' alleged attempt to poison him on February 14, 2022. And in the absence of a non-speculative basis for the jury to draw that inference, that is, that Eric knew that his wife had attempted to hurt him, there's no relevance to Dr. Venino's testimony regarding the dynamics of domestic violence relationships because there would be no foundation for the jury to conclude that the relationship between Kouri Richins and Eric Richins qualifies as a domestic violence relationship. In the absence of that foundation, Dr. Venino's testimony would not be helpful to the trier of fact under Rule 702A, and given its lack of probative value, it would be inadmissible under Rule 403, not only as not being relevant under 401 and 402, but also under Rule 403 as inviting the jury to speculate about whether there was some other evidence of a domestic violence relationship between these two that wasn't in evidence in the court. It might confuse the jury regarding the testimony that is admissible. It might mislead them regarding the reasonable inferences to be drawn from it. So sitting here today, there isn't a basis to allow Dr. Venino to testify. However, the state makes a reasonable point that the court hasn't seen all the evidence, isn't aware of all the evidence, hasn't seen how it would come in, and the state may yet be able to lay the missing foundation during its case in chief. And so while the court determines that sitting here today, there is not a basis to allow Dr. Venino to testify, the court acknowledges that that basis may arise through the state's case in chief if the state in its case in chief lays a sufficient foundation for the jury to draw a non-speculative inference that Eric Richins was aware that defendant tried to hurt him on February 14, 2022, the court will revisit defendant's argument that Dr. Venino's testimony should nonetheless be excluded under Rule 403, given the entire context of the evidentiary record at that point. In so ruling, the court also rules that Dr. Venino is qualified to offer this type of testimony under Rule 702A, and that her testimony, if it becomes helpful to the trier of fact, and if it survives a 403 balancing test, satisfies the minimum threshold for reliability under Rule 702B. Ms. Shervanek, Mr. Bloodworth, do you need any clarification in the court's room?
No, Your Honor, that's sufficient. Thank you.
Ms. Nestor?
No, Your Honor.
Okay. All right. Any other expert witness issues we need to handle today, Ms. Lewis?
Not today, Your Honor, no.
Okay. Mr. Burmester?
No, nothing for
Ms.
that.
Shervanek?
No, Your Honor.
All right.
No, Your Honor.
Okay. Sitting here at this moment, I'm not prepared to get too deep into the other motions in limine. May we take those up tomorrow? Any practical considerations that we need to think about, or are we just going to handle those one at a time tomorrow based on the papers?
Those are mostly going to be mine, Your Honor. Some of them are Ms. Lewis's. Alex has, I think, one or two. Mr. Ramos, sorry. The only question we had, and I'm just not sure. So these motions were filed privately because they deal with evidence that we're asking not be admissible at trial. I didn't know if the court intended to have the hearing public or not public, because once it's aired, it defeats the purpose of why it was all filed privately.
There is some space between the way we talk about stuff and the documents. For example, there are certain documents or transcripts in which the state is seeking to admit a portion but not the whole thing, and it's sometimes because the part they're not seeking to admit would be unfairly prejudicial, not relevant, inflammatory.
Right.
Nonetheless, your point is well taken. Do you have a request?
Obviously it would be our preference that it all be private, and then maybe your ruling could be public.
Sure.
Because your ruling can craft it in such a way that you don't reveal inadmissible evidence. But it seems to me that the danger that a bunch of inadmissible evidence is going to be broadcast to all of our jury who now have received jury questionnaires and know they're on deck could be problematic. So we would ask that the hearing be sealed and then maybe just the ruling be made public.
Okay. What's the state's position?
No objection to that, Your Honor.
All right.
They're closing the hearing tomorrow.
Tomorrow, January 8th, the court has set a hearing to hear oral argument on numerous motions in limine filed by the state and by defendant related to a number of pieces of testimony, documents, audio recordings, video recordings, other pieces of evidence. The admissibility of those things is as yet undetermined. And the court is persuaded by counsel's stipulation that to ensure the integrity of voir dire and the jury pool, and in recognition of the fact that potential jurors have already filled out their questionnaires, and so there would be a reduced ability tomorrow, the day after, to investigate whether they're exposed to information regarding inadmissible evidence. The court finds that it is necessary to close tomorrow's hearing to the public and to seal the audio recording of it so that it is available only to counsel but not to the public at large. The court's ruling regarding what is admissible and what is not will be part of the public record. Any clarification on that, Ms. Nestor?
No, Your Honor.
Mr. Bloodworth?
No, Your Honor.
All right. Folks, we're likely to get some weather tonight, tomorrow morning.
Nice.
Is 9:30 an appropriate time? Do you need a little more travel time?
10.
That's fine. 10 a.m., Mr. Bloodworth?
Yes, Your Honor, that works. I have one other
Please.
issue.
I did too, but go ahead. Oh, I just had a question. I don't know if you're prepared to answer this, but we do have a number of motions tomorrow, and in terms of expediency, it would be helpful if you have specific things you'd like us to be prepared to address. Maybe if we knew some of that in advance, if there's particular case law you want to discuss.
Got to hear them all.
No, I'm going to be going off. I do have lots of practical questions about, all right, who's offering this? How's it coming in? Right? Is this case in chief? Is this in repeat? I need to understand the order of events. But We'll go off the papers. And I'm happy to follow your lead in terms of the order in which you want to do things. So talk to each other. If you want to do Mr. Ramos's first so he can go do something, that's fine. Will you just tell me how you want to
He doesn't get to leave.
Okay. Anything else, Ms. Lewis?
No, Your Honor.
Mr.
I have
Glover.
to be here.
Your
He
Honor,
has to be here.
clarification on the ceiling.
Yeah.
The victim and defendant's family are permitted in the courtroom?
Certainly victim representative.
Just one.
Just one.
Okay.
Yeah. Would be similar to what we would do for jury selection, for example. So during individual voir dire, victim representative is allowed to be present. I don't even know if Ms. Richins wants a family member present.
I'm sorry. No, out of abundance of caution, because they've received subpoenas, it's
Right.
probably better they not.
Okay. So if you would pick a representative for the Richins family,
I think there's two that are designated.
that's fine. I understand. Yeah.
Your Honor, one more thing. The state in some of its motions have styled them as motions to pre-admit.
Right.
The defense in some objections had said the state lacks, or the court lacks authority to pre-admit. I don't fully know what the answer is, but...
Well, no, I certainly have the authority to say that, for example, defendant has admitted that she wrote a certain letter, so 901 is satisfied.
Sure, that. But as far as the relief the state is requesting, if the state has styled it as a motion to pre-admit, the state would like to amend any of those stylings to a motion to determine admissibility.
Understood.
Thank you.
Okay. Some of my questions will be, is there a genuine issue regarding the the authenticity of this document? Who's your witness that's going to bring it in? Something like that.
Yes.
Okay.
Wow. Anything else?
No, nothing further.
Okay. Ms. Nestor, Ms. Lewis, Mr. Ramos, I'm not suggesting that the defendant should do anything other than put the state to its burden of proof and require them to lay a foundation for stuff they want to admit. However, I do want you to be at least a little bit thoughtful on both sides of the V here about the juror's time and the court's time. And so if there are indisputably authentic documents that you can stipulate regarding authenticity and foundation, but you want to reserve and then discuss your arguments regarding admissibility,
Right.
let me know which one those
Your
are.
Honor, I actually have been spending a great deal of time on that. I've come up with lots and lots that we're willing to stipulate to authenticity. I told the prosecution I would get that to them, I think Monday, but something came up in my family and I wasn't able to do that, but I will try to get that to them by Friday.
Okay.
But there's quite a few documents that we're not going to have a problem with authenticity, and we're not going to ask them to bring in sponsoring witnesses or like jail calls and bank records and pictures and all that kind of stuff. And I mean, I'm doing it one by one by one, and will have a comprehensive list by Friday, hopefully.
Thank you.
Good. That'll make the court a lot easier
Mr.
to
Glover,
watch.
anything else today?
No, Your Honor.
Okay. Ms. Lewis?
No, Your Honor.
All right. We'll reconvene 10 a.m. tomorrow morning.
We will not see it.
2 victim representatives are welcome to attend. The rest of the public will be excluded tomorrow. Please travel safely. Nice to see all of you. Please take care. Court's in recess.
All right. So as they go to recess, tomorrow is going to be spicy, and we don't get to hear about it until the judge makes a decision, and then we might only hear about it in reference to such and such a video numbered this, or the video from this establishment from this date. We have to watch for that. We have to watch for the document. I think we have to watch for the judge's ruling as soon as it comes out. There's a good chance it might have some stuff that the defense later objects to once it's released, and then it gets put back under seal. So we have to watch for that right when it comes out so we can grab it. Because if we get it when it's not under seal, it's fair game. And I'm curious. I really am. It sounds like there's a lot of different evidence, probably all the evidence that the defense just doesn't want to have come in. Kouri doesn't even want her family there to hear about some of this stuff. So, interesting. All right. Yes, there's another thing tomorrow. Unfortunately, Judge just, you heard him there, just barely sealed the meeting to the public. No press will be there. It will not be recorded. Transcription is going to be sealed as well. Possibly until after the case is over, maybe forever. So I can listen to this judge all day long. I love that he's not biased and he's being respectful of Kouri's rights. He is a great judge. He really is. All right, Park City weather, possible 1 to 4 inches of snow overnight. That's not much for Park City. I realize 1 to 4 inches here in North Carolina would shut down the state in many parts, specifically where I am in eastern North Carolina. 1 to 4 inches in Park City, they might not even send the plows out. That's just like, that's a Tuesday for Park City. Park City is a ski resort town. It used to be a silver mining town way back in the day. A very poor town to begin with. Now it's basically like Vail, Colorado, but in Utah. It's a ski resort town. You've got all sorts of ski resorts up around the mountains in these areas, and they get 10 feet of snow a year in some of those resorts. So 1 to 4 inches. It might slow down traffic a little bit if somebody spins out or something in the canyon. Parley's Canyon is the problem. There's basically like one route between Salt Lake City, where some of these lawyers live, and the courthouse, and it's a big steep canyon with a section called Lamb's Canyon that is brutal for accidents, absolutely brutal. Utah ski, yes, the slogan for Utah is "Greatest Snow on Earth." That's what they say on their drivers on their license plates. We have powder there that is unbelievable. I've never skied. I mean, I put skis on one time, and I went about 10 feet, and I ended with my legs going different directions. Like my right leg was left of me, and my left leg was right of me, and I was falling in the middle. It was terribly painful, and I was done. Like, this is not for me. All right. Anything else? Fun day today. Really fun day. We're a little bit early. It's only 3:30. So the judge really got through everything quickly. The Paltrow ski trial was in the Richins courtroom. Yes, the very same one. I can teach you how to snowboard, but you might have to sign a waiver. AWOL podcast, I do know how to snowboard, but I've never snowboarded at a resort. I know this is crazy for, Utah had the Winter Olympics there and, all the ski and everything else. I've never snowboarded at a resort. My idea of snowboarding, first of all, was buying a plastic snowboard because I was too poor to buy like one of the real waxed ones with the metal edge, and then putting on my winter bibs and boots and coat and hat and gloves, and then hiking up the mountain where there are no trails and just up a snow-covered mountain until you basically can't walk anymore, and you nearly pass out from exhaustion, and then you rest, and then you go further. And then you get one run down, and it is pure bliss. The feeling of snowboarding in waist-deep powder is unbelievable. You're floating on clouds. It lasts for 2 minutes, and you're down off the mountain, and you're done. That was your day. That was it. Let's see. Update on case we watched yesterday in Mod Chat. Let me look and see which case you're referring to. Bond hearing January 21st for defendant on the trial we watched and sentencing February 19th. That is the Warren County trial with Judge Teep, Mr. X. So that was the forgery trial we watched. So thank you, Josh, for that. Bond hearing January 21st, sentencing February 19th. All right, let's see. I did that water skiing and sprained an immovable joint in my pelvis. Oh my goodness. I've had some bad wrecks on water skiing. Kneeboarding actually was a difficult one. Kneeboarding, you're supposed to start laying on the board with your feet trailing, and it's pretty easy to get up on the water. But once I got up and I got like to where my knees were on the kneeboard, and I had the strap over my knees, and I cinched it down tight so that you can jump and the board stays with you. I was being pulled by a boat that had like a 454 racing engine, and it was a very light boat, and it had tons of power. It nearly rips your arms off, and it throws this incredible wake right? This is amazing. It's like a 3-foot tall cliff. And so I'm kneeboarding behind this thing, and it's like super smooth. Like, this is crazy. And then, of course, it does the first turn, and I get thrown out off the wake, and I'm like, whoa, and I land, and suddenly it becomes super choppy. It was so choppy, like, this is not fun anymore. And so I cut back in to get back on the smooth part in the middle of the wake. I caught the tip of the board in the water and face planted. The hardest I've ever face planted on water before. And I'm not a cliff jumper, so I imagine harder face plants can happen, but this was my hardest. And I distinctly remember a couple things. One, the strap on the kneeboard did not come off. 2, I did not let go. And 3, I distinctly felt the back of my eyeballs being flushed with water as I was dragged underwater behind the boat, holding on for dear life to the rope until I just gave up. So that was my kneeboarding crash experience. Rinse the back of your eyeballs. That was fun. And it was so cold, by the way. It was so cold. I was up in Wyoming at a lake called Fremont Lake, which is a glacier-fed lake. I think it's the deepest lake in Wyoming, actually. Come to think of it. I think so. All right. It has been fun to be here. Donna Barkley, it's good to have you here. Welcome. You're amongst friends here. Please come back again. We've got some more court hopping. We might have a case here very soon to jump to. Nothing to announce yet. Let's see. The Recovery Addict, we've been going all day with virtually no lunch break. Just saying, I know. And the mods, thank you so much. You are amazing. Just got back from a romp with the dog. Do not ding dong ditch us. Kelly, it's time to go. I've got to have a break. I've got to get some food. I've got to check on Mrs. R.A. To make sure she's doing well. Did you just say Fremont Lake? I did. Gigi, have you been there? Just outside of Pinedale, Wyoming, on the edge of the Wind River Mountains. I have memories from that area. I used to go there every single summer with the Boy Scout group, and we would boat across Fremont Lake to the inlet side where our troop, like my group, we built that campsite. It didn't exist before. We had permission from the Forest Service and everything. We built that campsite. We built the dock that was there. Yes, that's where I learned to water ski. Fantastic lake. Amazing fishing. Oh my goodness, amazing fishing. And what's the name of the store? It's like a grocery store, sporting goods store, everything there in Pinedale. Starts with an F, maybe? Can't remember. But great story. I always would get my fishing license there for the week. Anyway, Failures or something? I don't remember what it was called. All right, tonight when you go home, please hug the people you love, smile at someone, make their day just a little bit better, and please stay safe until we go live again tomorrow morning. Wait, I just sent something 3 times. Never mind. Focus needs to happen. Okay, I'll check. Gosh, I'll check. Fletcher's it is. Okay, that sounds right. Yeah, please stay safe until we go live again tomorrow morning, about 8:45 to 9-ish is the plan. Uvalde's about to miss trial. I told you that was a bad one. We're steering clear, but for a reason. All right, you guys, have a wonderful day. We'll see you tomorrow. Have a good one. Bye-bye.